Drew Miller. Drew is a partner in the Austin office of Kim Smith LLP, where he is chair of the firm's Environmental, Administrative, and Public Law Department.
Well, thank you, and thank you, Cypress, and to TOPCA for having me at this event, and I appreciate the turnout at this late hour. In the world of water law in Texas, the big happening that's on everyone's mind for the past year is the Texas Supreme Court's decision in the Edwards Aquifer Authority versus Day case. We shorthanded as the Day case. It's been called the most important case in the subject of groundwater in Texas in a century. And that decision, which answered some questions that have been around for, I think, as much as 50 years, has also received the attention of scholars and practitioners of water law around the country. Last time I spoke about the Day case was at a conference at UC Hastings Law School in San Francisco with a panel of professors. So that gives you an idea of the interest, the nationwide interest in the Day case. A lot of people talk about the Day case. Again, I think, and I appreciate the introduction, but I think I'm qualified because I was one of the lead lawyers in that case. And to be clear, my firm represented the Edwards Aquifer Authority, and we were on the losing side of the Day case. By a show of hands, can I ask how many of you are aware of the Day case?
Only 3 years stressed.
Well, okay, just a few. Okay. Well, well, to kind of to pinpoint it or to hit it on the nose, the Day case concerned the issue of ownership of groundwater in Texas. Susanna has provided a good backdrop, I think, a context for my discussion of the Day case, and I am really going to focus on the Day case for my prepared remarks. By covering the rule of capture and also by covering the world of groundwater conservation districts and for introducing and summarizing those topics. Groundwater conservation districts, on one hand, are given very broad discretion on how to manage groundwater withdrawals. In contrast, the Edwards Aquifer Authority, the Edwards Aquifer Authority based in San Antonio is really the odd man out. In that the Edwards Authority was given very specific mandates from the Texas legislature regarding exactly how to manage groundwater withdrawals within its jurisdiction and how to allocate future pumping rights. You may know about the Edwards Aquifer, and for the sake of time, both for that reason and for the sake of time, I won't go into great detail about it, the aquifer itself, but suffice it to say that the aquifer serves as the sole source of municipal water supply for millions of people, provides water for large-scale and small-scale irrigated agriculture, and feeds springs that in turn feed rivers that supply cities and industries downstream. The springs and rivers that depend on outflow from the Edwards Aquifer also support tourism, which is an important part of the economy in San Marcos and the Braunfels area, and also, of course, support the environment, including the local flora and fauna. Before I get into the Day case, I want to talk about the circumstances that gave birth to the Edwards Aquifer Authority and to the system of Edwards regulation that we've had for some 20 years, 15 years at this point. The Edwards Aquifer Authority exists. They've been involved in litigation, but they also exist as a result of litigation. And the litigation I'm referring to is litigation initiated by the Sierra Club in the 1990s. Sierra Club sued the pumpers in the San Antonio region, alleging that the unrestricted pumping of groundwater from the Edwards resulted in reduced flow at Comal and San Marcos Springs, and thus caused the illegal take of endangered species that depended on those spring flows in violation of the Federal Endangered Species Act. There was a federal judge, an activist federal judge, Judge Lucius Bunton, who heard that case and agreed with Sierra Club. And he threatened to regulate withdrawals of groundwater from the Edwards Aquifer unless the state of Texas took immediate action to do that and to protect the spring flows on which the endangered species depended. So in 1993, the legislature, Texas legislature responded by enacting the Edwards Aquifer Authority Act, which capped permitted withdrawals from the Edwards and allocated rights to continued pumping to well owners who could show beneficial use of Edwards groundwater through, during a historical period, being 1972 to 1993. And the legislature created this body, the Edwards Aquifer Authority, to administer the regulatory program. Well, the EA got to work in '96, and 10 years later finished this giant round of permitting 10 years later in 2006. The legislature also intended that a market would develop for the sale and transfer, the lease or the sale of these Edwards permitted rights, and indeed that market developed and exists. Okay, let's shift to Day, and let's talk about the plaintiff in the Day case. Mr. Day and his partner applied for a groundwater withdrawal permit from the Edwards Aquifer Authority, and the Edwards Aquifer Authority issued a permit to Day for an amount that was mandated by the EA Act, given the small amount of historic use on that property, which was much less than the amount that Day had requested. So Day filed a lawsuit against the Edwards Aquifer Authority, challenging that decision, alleging numerous legal errors. Okay, a little background on takings claims. Both the United States and the Texas Constitution provide that the government may not take private property for public use without providing just compensation. Okay, originally the idea of compensation for taking a property applied only to instances where the government physically occupied a landowner's property, for instance, quartering troops on your property or taking a portion of your property for building a road. The government has to pay for that, right? Pay just compensation. But beginning in the 1920s, there began a concept of a regulatory taking, which means that even without physical occupation, it's possible that the government could so burden your property with regulations that those restrictions and those regulations are equivalent or amount to the taking of property, private property, requiring compensation. Okay, so back to Day. Day's lawsuit included a regulatory takings claim that the authority's decision on Day's permit application amounted to a regulatory taking of Day's vested ownership rights to Edwards groundwater under his property, entitling Day to compensation. Well, the trial court threw out Day's takings claim on the ground that Day had no vested right to groundwater beneath his property prior to capture, which may be the subject of a regulatory taking claim. The Court of Appeals reversed, holding that Day has a vested right in the groundwater, and both sides sought and were granted review by the Texas Supreme Court. I could get into the arguments, but it's kind of water under the bridge at this point.
And we wouldn't understand.
Well, I would try to make it engaging and understandable. But in a unanimous decision issued almost exactly a year ago, the Texas Supreme Court addressed this issue of the nature of the ownership right of groundwater in place, and held that, that such groundwater in place prior to capture was entitled to protection under the Takings Clause of the Texas Constitution. The way the court approached the issue is they declared that the common law of ownership of oil and gas applies to groundwater. Under the law of the ownership of oil and gas is owned in place prior to capture. They're considered part of the realty, and the landowner is regarded as having absolute title to these substances, which each landowner owns privately, separately, distinctively, and exclusively as a result of his proprietorship of the land. So, therefore, like oil and gas, the landowner's right to those substances prior to capture is entitled to protection under the Takings Clause. The court left in place, left intact, the central aspect of the rule of capture, which that a landowner has no private cause of action in court against a neighboring well owner who, by virtue of a deeper well or a more powerful pump, drains all groundwater out from under the landowner. I think that mostly in hindsight, the holding of Day isn't a surprise. It shouldn't be a surprise, given the politics of the court, the fact that the court is elected, the fact that the court is very conservative. In some ways, the more difficult portion of the Day decision is not that holding, but the court's dicta. Okay, and the term dicta, a term that lawyers like to throw around, dicta is a portion of the legal court's opinion that's not necessary for the court's holding. So we like to say that dicta is not binding precedent in subsequent decisions or in lower courts. But that said, the dicta in a unanimous opinion of the Texas Supreme Court needs to be looked at because it's going to provide an indication of the direction that the court will go on issues that may come before them in the future. And the Day case, if you read it, it's long and it's just really a dicta bonanza. And so what Judge Heck did, supported by all the other judges, is really make a series of statements on what it likes and what it does not like with respect to groundwater regulation in Texas, not just with regard to the Edwards, but with regard to all those other 95 or 98 groundwater conservation districts scattered around the state. And to very broadly summarize, the Texas Supreme Court does not like a system that allocates groundwater based solely on historic use. And that's exactly what the legislature prescribed for the Edwards region. It has been thought that these local groundwater districts have the freedom to prefer historic use. In fact, the statute says they do. But the Texas Supreme Court doesn't like a system that really places all or most of the preference, gives most of the preference for future withdrawals based on historic use, which we just heard. That's the system regarding surface water, prior appropriation. But the Supreme Court doesn't like it with regard to groundwater because of this ownership concept, this private ownership concept. Supreme Court does not like any system that denies a landowner all access to his groundwater. The Supreme Court likes an allocation system based on land ownership, but recognizes that land ownership should not be the only factor considered. The Day case is on remand. Not much or nothing has happened in that case on remand, meaning it's back in the lower court. There's the Supreme Court simply said that you can assert a takings claim, and said a lot about what it thought that takings claim a court should consider, but didn't make any ruling on it. There's another case involving the Edwards by pecan farmers in Medina County, known as the Bragg case, based on the name of the plaintiffs, the Braggs. That case is actually, there was a ruling by a lower court that the Edwards Aquifer Authority's regulation to deny one permit and then issue a permit in amount said to be insufficient to water mature pecan trees, that those decisions constituted takings and assessed a judgment, an amount for both of those decisions, the denial and the partial grant. That case is up on appeal, and there's some very important issues for the Edwards at stake in that appeal. It's been fully briefed, and the court is going to hear oral argument in that case on March 28th. So that's coming up. So where does that leave us? Where does the Day case leave us? Well, for the EAA, okay, quickly, for the EAA, the Supreme Court has made it clear that it does not like the Edwards-style regulation. That was established and mandated by the legislature in 93. For the other 95 GCDs, the Day case presents some serious challenges, especially for a district that is interested in providing some preference to historic use. I was going to close, I don't have time, but I was going to close by reading a resolution from the Fox Cross Groundwater District that came out that the board voted on and approved after the Day case. And essentially, this board is here they are, they're supposed to be groundwater managers and regulators, but they never came around to the view that that was the right thing to do. And so what they did after the Day case is it said that they just voted to disband. So this is kind of extreme, but it does represent a kind of a view that exists around the state that you know the groundwater is private property, and that no one has the business of telling anyone what they can do with the groundwater. I think the legislature disagrees, and the Supreme Court disagrees. But how you regulate and how you allocate rights, you may have to compensate for it. And frankly, if you have to compensate for it, you're not going to be able to do it. Where those lines are going to be drawn in the future, that's subject to a lot of speculation. It's going to take many years to work out.